that restore ecosystems. So we're getting at things that we want to have better skill set or background. This made explicit in A and B. Sorry, A and C. B says we're aiming for balance. And it can be interpreted in more than one way by the appointing authority.
If someone were to ask how many bunny huggers are likely to be on this, or what would a student of politics, this building and language conclude as a range?
Well, I would have to go and look for the definition of bunny hugger in the definition section. We don't find it operationally, so.
We accepted it as
I
a
don't-
term for the development of the bill.
We did not,
No.
we did not. In fact, some folks might even consider it a insult.
A slur.
Yeah,
Yeah, so.
If it is a joke, be funnier.
yeah, exactly. But I hear what you're saying.
What am I saying?
You're saying that you wanna make sure that there's balance on the board, even though we've taken out the appointing
The
authority.
measurements.
Yeah.
No.
Exactly. Which.
So
I think-
it will be a judgment call, and we have criteria in here for the skills and different background we're looking for in the individuals. And it is my hope and belief that the appointing authorities will consider, well, they're literally obligated legally to consider those. What happens? I don't,
Are you?
I'm not gonna
have you
try to
ever
predict.
been?
not gonna try to predict.
So the chair just referenced the additional change on page 2 on 16 through 19. The part of the consideration that the appointing authority will provide to applicants is whether or not they recognize challenges to wildlife habitat caused by climate change, including loss of the biodiversity and the prioritization of the value of science and work to conserve and restore natural ecosystems. They continue to receive training from the department on wildlife management and hunting, such as the North American model of wildlife conservation. Upon filing proposed rules, that basic procedure of the department drafts the rules, gives the rules to the board for review to determine whether or not the utilization of a regulated species. So this is still focusing on those species that are subject to hunting, and fishing, fish and wildlife game. And so moving on to the bottom of that page.
I'm sorry, can I just flag for people who might worry that it was left something behind, we have. My numbers, I printed this out and I don't have the number, but we also have and other necessary desirable species that are ecologically related to regulated species, so.
Right, and that is in the current law for the Port Authority. And that's why I say that I believe the Port Authority is larger than just fishing game and taking of fishing game, because they have to manage species that are regulated to them as well, related to the fishing game. So I think the board's authority is already broader than just the taking of fish and game. But others disagree.
Yeah, the plain language seems to suggest, and for people who are saying what's going on with the language, we're in some cases reverting to original language that, so that if people are concerned about what we asserted versus what the original language was, once they're reassured by the original language.
So in section 1 of your proposal, there had been an amendment striking 10 U.S.A. 4042, which is a section which basically says the commissioner shall be appointed according to the appointment process in Title III. You don't have that kind of specific language for like the Secretary of Natural Resources or Forest and Parks, but in the interest of reducing what is being amended to avoid anxiety, that language and that amendment is 10 VSA 4042 is being removed. And you will see, just by the nature of that first instance of amendment. It is only reinserting 4040. Um. And then in the second instance of amendment, this is in 10 VSA 4082. Which is. The Fish and Wildlife Regulation Authority. It remains that the department is the entity adopting these rules. It remains that they have to adopt these rules for the best science available. What is changing here is that had previously said that the board would be adopting rules for all wildlife. And it's now just for, the department would be adopting rules for all wildlife. But now it is just reverting back to the utilization levels of the regulated species of fish and wild game. So this is not about all wildlife anymore. This is about fish and game and those that are ecologically related to the regulated species.
So that, those that are ecologically related to the regulated species. I think that the rules this speak, the regulations. When I think about them, they're always focused on game that we can take. I don't know that I've seen a rule about related species that you can't take. Are you aware of any? Really threatened and endangered, but that's in another bucket entirely.
I think there might be revisions in the fish rules, but I would before. Many that I'd have to go that.
All right, okay, right. I wasn't thinking of those. Yeah, thank you.
What's wild game?
It's defined, on 10 VSA 4001, by that definition if you would like.
This is synonymous with wildlife. Oh no, because it's also what you take. Subset.
What's just plain game?
Well, you will see that they're the same thing. Game means game bird, game fodder, pets, or both. Game birds are quail, partridge, woodcock, pheasant, plover, venus, Wilson snake, other shorebird, rail, coon, gallinule, wild ducks, wild geese, and wild turkey. Game fodder, pet, are caribou, elk, moose, deer, gray squirrel, rabbit, and black bear.
What are coyotes?
Coyotes are fur-bearing animals.
I have a question. I just wanted, I'll mention the word. They were exempted from the one waste, though.
There were provisions that are different for coyote. But you can say they were exempted as to they're different provisions.
Okay, thank you.
Bear is just certain bears names.
Bears and being fodder pet. So moving on to the third instance of amendment, there was a amendment to 4048 in your proposal of amendment. Which had the Commissioner of Fish and Wildlife consulting with the board and adopting a rule establishing a plan for non-game wildlife. If the board is focused on just fish and wild game and the taking thereof, they really shouldn't be consulted for the non-game wildlife management plan. However, you had also required the commissioner to consult with the Endangered Species Committee, which may include non-game. Likely will
Yeah,
for the most of the game, so
Ideally,
that will remain, that consultation with the ESC will remain. In the fourth instance of amendment, all of your proposals relating to trapping. Definition of trail. The setbacks and the definitions used for those setbacks are all removed from the bill. And the bill is reordered in numerically correct. So there still remains the repeal of the Fish and Wildlife Board definitions and rule regarding the taking of coyote with dogs. There is still the repeal of the permit that the Commissioner of Fish and Wildlife issued for the taking of coyote with dogs. But there is no longer anything in, or there would no longer be anything in the bill up to the proposed amendment is adopted. Without trapping and the trapping rules approved by the Fish and Wildlife Board this past fall, winter would be controlled, would be law, would remain law.
So the LCAR questions that came up, whatever, call them corrections, if you were to change definition of trails to ensure that there's not an exemption for traps. That you still have to honor that 50-foot setback requirement, even if you're setting underwater or ice. We had it, the board rewrote the definition of trapping to include the word hunt, which has constitutional and statutory implications, seemed like a policy decision, and therefore, and not necessary for the development of the rule that's actually brought forward. Are objective to that. But those elements are removed from this bill by this amendment, and it leaves the coyote provisions in that.
Thank you. I have a question about the third instance of amendment, and how it differs from, what was passed out of this committee. So it removes the board from consultation. What you can say about the logic?
So remember, as the board authority was coming out of your proposal, you were clarifying that their authority was to provide advisory advice to the department on regulation on all water. And the department and others were concerned about that. They said the board is only authorized or only intended to address fish and wild game and the species related to those.
Oh, because this is about
This is about mine.
I get it now. Thank you. Check. Great, thank you.
Perhaps that's being backwards, so they have a question about what's game and what's non-game. In an effort so that I could picture whether the rulemaking was going to professional department or the appointed board. And I don't have a picture in my head.
Okay.
So if someone were to make if folks were to come in with a petition to change the rules on traffic, where would that petition
To
go?
the department,
Coyote.
to department.
Game in general,
Yes, department.
or is there? And in each of the cases, and it goes to the department and the board has an advisory role.
Correct.
Am I missing anything that wouldn't go to the department in this greater discussion?
So what remains is what's the distinction between what are called the commissioner's rules and what are currently the board rules. Going into the future, you'll probably have just the commissioner / department's rules. So the commissioner right now has authority to adopt rules over issues that are unrelated to the taking of fish and game. For example, use of fish and wildlife lands, right? Use of fish and wildlife lands is a commissioner's rule. And because it's unrelated, well, not totally unrelated, but it's not something regarding specifically the taking of fish and game. So that's a commissioner rule. That's separate from the board's authority. The commissioner would not have to take that to the board for advice. Because the use of fish and wildlife lands is not specifically about the taking of fish and game.
Thank you. So now, Mr. Chair. There was previously, there was a definite, there were members of the board were appointed in what appeared to be two separate philosophies, sides, and personal history. And now that separation is removed. And the term, the standard is balance. And balance is determined by the appointing entities. So the proof will be
Great. There's one other petition opportunity is to petition Elkhart.
in which case the petitions will all go to the department and the board will have the opportunity to weigh in and advise.
Not that you go to.
I just also want to say that the fish and wildlife regulations are unique in how they were formed and how you as a body have the authority to revise them. In 1961, when you created, the General Assembly created the fish and wildlife regulations, you did it in session. And you gave yourself the ability to amend those regulations along with the Fish and Wildlife Board. So if you want to amend those rules without going through the rulemaking process and just going through the legislative process, you can do that.
Which is what we're doing right here now, right?
And I will say that if anyone doesn't recognize that authority, then the Fish and Wildlife Board regulations don't exist. Because there was a provision about 10 years ago that said, in order for a rule to continue to exist, the department had to file that rule with the Secretary of State for posting by the Secretary of State for public review. Fish and Wildlife Board did not file their rules, and the Secretary of State was going to repeal all of those rules. And I was the one that said, you can't repeal session law. De facto Secretary of State, they need to remain in force, and that's why they are there, because otherwise the board failed to file and those rules could have been repealed entirely.
Right, and it's that language from Act 119 of 1961. Plus the way we deal with an APA that makes me entirely confident that the bill as originally passed out of committee for approval. However, discussion with parties who had concerns has led to amendment. So we'll see if the amendment has the intended effect. So before we go on 259, which is we're taking some testimony on that. I would like to ask that we take a informal committee, so we have a committee position to report on amendment. For
Sorry to take my time, but I have one question before.
we do.
And just verbally, a side by side, present law, what the law will be if this bill were to pass as worded here.
So with regard to Fish and Wildlife Board governance, you're maintaining the 14 persons appointed by county by the governor. There's no longer a 5-5-5 split in appointment. The Speaker of the House will appoint an at-large member. The committees will appoint another at-large member. And then you're clarifying that the subject matter that the board will advise the department on will relate to the taking of fishing game and regulated species or species directly related thereto, instead of all wildlife. So that's the governance, generally the main governance. You're no longer making that distinction between licensed and non-licensed users and balanced representation of those entities on the board. Your proposal of amendment, the committee's proposal amendment would have repealed the Fish and Wildlife Board provisions on setbacks for trapping, the definition of trapping, the definition of trail. You are removing those provisions from the Senate committee's proposal. And therefore the Fish and Wildlife Board rules addressing all of those subject matters would remain in place. You continue both under this amendment and the Senate committee's proposal of amendment to repeal the Fish and Wildlife Board's rules regarding the pursuit of coyotes with dogs.
Any other questions for council on the amendment for 258? All right, so that I can report where we are. Committees on this proposal. Also,
That's good. So what would be the status of hunting coyotes with dogs?
So the department actually issued a license once the rule was filed and they interpreted the moratorium was being lifted. They issued a license, they had a season, the season. Somebody can correct me, it either ended last weekend or it ends this weekend. Can't remember. Anybody know? Either March 15th or March 25th.
That was the 31st.
The 31st.
I'll check.
So it by the time this is enacted, the season will be over. So you won't be affecting any issued licenses.
But next season will take place.
That season won't take place.
Won't take place
Even with the event.
until
You
there are. So there's a law that says it'll take place, or there are rules.
you have
It'll take.
repealed the authority of the commissioner to issue a permit. Whether or not somebody then petitions the Fish and Wildlife Board, the Fish and Wildlife Board takes up the rulemaking process to do it again. Theoretically, that's possible. Theoretically, that's possible.
if a new rule were issued in that way, wouldn't the statute still control?
Well, you have to look at what you did,
Is it striking?
right? You,
Permanent moratorium.
right, so you have this provision that says. No person shall pursue coyote with the aid of dogs either for the purposes of training a dog or taking a coyote. So if there is a petition to the board to regulate. Hunting coyote with dogs, they have to be consistent with statute. Because if statute and rule conflict, statute controls. Because of the authority that any rule is. The authority is not executive authority, but you give a rulemaking entity as legislative authority. And you direct them how to use that legislative authority. It is not executive branch authority, that is the legislative authority. And you can amend that grant of legislative authority as you wish. And so you have said that they don't have the legislative authority to allow for the pursuit of coyote with the aid of dogs for training or a dog or others, but somebody could still petition.
Right.
And the board could still go forward. And agencies propose things to Elcar all the time that conflict with statute. And then it's
But
like,
he would control.
right.
Why would they be petitioning the board? Why wouldn't they be petitioning the department?
Yeah, that's,
They would be traditionally
Yeah.
department, you're right.
Okay, so I have that.
Yes.
yeah, that's,
I'm sorry.
So. Very. Those. They were existed in the last year or two with a. Intention of this committee to permit coyote hunting with dogs. Pursuant to rules to be written about dogs being under control. And. Now, and what we're getting is a black and white, no coyote hunting with dogs.
Right.
And to reinitiate the opportunity to hunt them when dogs were under control. Is something the legislature would have to
The
do,
legislature would have to do that,
and
yes.
the previous system missed its opportunity. To have done that. It's just, we've enabled that to happen. Under rulemaking and. It failed because the board didn't make any rules. So now that would have to start in. Legislatively. To authorize. Future rulemaking in that direction.
Yes. I mean, yes to that final question, the pretext for that. Some would agree with someone.
And Mr. Chair, I learned that when you use expressions in the committee meetings, sometimes they get taken out and published and online or whatever. The term bunny others is what people who had testified in the past before the board have come in and told us that board members during their breaks referred to them as
Yes.
bunny others. And the bill that we were considering divided. Had representation for people that were defined as hunters and the people that were defined as non-hunters. And that's gone, that separation is gone in favor of people that are balanced. Is that correct? Balanced views.
There's an ABC, balance is B, before and after, there's other criteria that. Are there to aid or drive the selection. and Appointment of new members.
And that's senators, we hope that. Appointments reach the level of balance that we currently have amongst the members of the legislative bodies, which of course are balanced.
We need that committee position, so if I may, once there's further discussion on 258, the amendment to 258. So all those in favor of the 258 amendment that we offer today, please say aye.
Aye.
Anyone opposed, please say nay. Okay, so 500 for committee position on 4 when I report it. Thank you, everyone.
Thank you for. Working on our behalf to try and bring the balance that we hope we will see in the future and include these issues. Kind of, thank all people who called in and you spoke to us about that.
Last
Both sides.
editorial comment, I say this bill was never opposed to things that was about improving public safety, improving the democratic conversation around management, wildlife health and public trust. And from many conversations with people all over this, and there is a common interest in healthy population wildlife, healthy habitat and conservation. So I'm gonna say it again, it sounds what I mean, there's much more that unites the two quote unquote sides than divides. I think once enough people spend time together, we find that out. So thank you, everyone. We need to go on to 2:59. We have a shortened time. Mr. O'Grady, if you can give us a high-level introduction to the bill. We have one witness who's joining remote, and if you could tell us, if you could focus on the Superfund and the piece related to, we're gonna have to measure impacts in order to understand how to do an assessment ultimately. That's what our witness is here to talk about. Mr. Mason.
Professor Mann, Dartmouth.
S 259 establishes a program to recover from responsible parties. The cost to Vermont of from covered greenhouse gas emissions during a period from January 1, 1995 to December 31st, 2024. But what is recovered from these responsible parties, and responsible parties would be basically fossil fuel companies that refine petroleum or extract fossil fuels. Those cost recovery payments will be deposited into a special fund to pay for climate change adaptation projects based on ANR's resilience implementation strategy and the state hazards mitigation plan. You asked for me to address how the bill is going to basically quantify the cost recovery payment. The cost recovery payment will be based on the ratio of responsible parties emissions, their responsibility for the cost to Vermont in the same ratio as their responsibility for the emissions, covered greenhouse gas emissions during the covered period. The costs to Vermont are going to be quantified by the state treasurer. State treasurer is going to issue a report that is going to be used as part of that cost recovery payment formula for each responsible party. And that's a 20,000 foot level overview.
That's perfect. I mean, we didn't formally take the bill. I think the interest in there, but in here in part is we should understand the fundamentals of the science and math underneath, like how are we gonna make this judgment, and how are we gonna have a system that creates an obligation. Thank you, Mr. O'Grady. So with that, let's go to Professor Mankin. Thanks for joining us.
Yeah, good morning.
I don't know if you heard what I was asking, so on behalf of the committee, we could understand the gears that are gonna turn out an assessment related to damages and turning that assessment into an obligation to contribute to the fund.
Sure. I'll just walk you through some high-level thoughts and then be available to take your questions if that makes sense.
Please, thank you.
Okay. Well, my name is Justin Mankin. I'm a professor of geography at Dartmouth, an associate research scientist at the Division of Ocean Climate Physics at Lamont Doherty Earth Observatory of Columbia University. At Dartmouth, my role is directing the climate modeling and impacts group, where we work to understand the human impacts of global warming. Our goal really is to improve our understanding of the consequences of warming for people and the things they value, and then to inform the difficult decisions that those consequences from warming will compel. My group's research has been published in leading peer-reviewed journals like Science and Nature and the Proceedings of the National Academy of Sciences. I hold an undergraduate degree and master's in public administration from Columbia University, a Master of Science from the London School of Economics, and a PhD in climate science from Stanford. I'm here to provide some testimony on S259. If there is one point you should take away from my testimony today, it is that using peer-reviewed consensus scientific methods, scientists can quantify the economic losses a region like Vermont has endured from the impacts of global warming to date, trace those losses back to particular emitters, and provide estimates of future losses. If you were to,
I was excited.
if you were to take away a second point from my testimony today, it is that any accounting of damages, such as the kind proposed by S259, is, in my opinion, likely to be an undercounting of the true losses a region like Vermont has suffered. And that is because these climate damage cost accounting methods are inherently conservative. They tend to focus on a single impact or hazard at a time, and they are often very limited by data. In general, there are 3 sets of costs to consider in assessing total damage due to climate change, and there are different methods to estimate each of these. The first is the one I'm showing here, the cost of the damage promulgated by historical emissions. So these are the costs that have already manifested in Vermont's economy owing to the hazards from human-caused global warming to date. The second set of costs to consider are the costs that will arise from future hazards, which have their origins in historical emissions, right? The effects of carbon dioxide or CO2 are cumulative, and CO2 has a very long residence time in our atmosphere, such that some fraction of the first ton of carbon released at the dawn of the Industrial Revolution is still up there, warming our climate and generating impacts. This means that the emissions already released from fossil fuel combustion, and to which we can already attribute historical climate damages in a place like Vermont, will continue to cause Vermont damage into the future. The last cost to consider is that from future emissions. Decarbonizing our economy will take time, and in itself will be energy intensive. And to the extent that that decarbonization effort is itself reliant on fossil fuels, future emissions will generate future impacts, and those impacts will generate costs. Now, there are peer-reviewed and scientifically defensible approaches to calculating the costs attributable to each of these terms, implying that the treasurer would have options on how best to approach any accounting. But in general, they all rely on what we call an attribution of losses. And this attribution is typically constructed using quantitative models to estimate, say, what Vermont's economy and climate would have looked like without global warming attributable to particular sets of emissions, such as the emissions that have been sourced to particular fossil fuel firms by researchers like Rick Heady. So briefly, climate attribution science is extremely well established. It is a consensus science informing synthesis reports like the Intergovernmental Panel on Climate Change and the United States' National Climate Assessment. And these assessment methodologies have been used to establish causal links between global warming and various climate hazards like floods or droughts or heat waves or snow loss or tropical cyclones, among others. Similarly, there is considerable peer-reviewed consensus science work that documents and attributes the monetary losses from climate impacts, what are so-called climate damage assessments. And these connect climate-related extremes like heat waves or floods to policy-legible socioeconomic outcomes like lives or income lost. And with these damage estimates, decision makers can better understand the costs of climate inaction and weigh them against the net benefits of adaptation and mitigation. Now, these attribution methods rely on comparing outcomes in 2 groups, just like in a medical drug trial. In a drug trial, participants are randomly assigned into a treatment or a control group, and the individuals in the treatment group get the drug, and those in the control group do not, and the medical outcomes among the 2 groups are compared to assess the efficacy of the treatment. And we can extend this toy example to climate attribution in general. We are comparing outcomes in a world with versus without climate change or without a particular set of emissions. As you can see here in this figure, the distinction is that we're using models rather than a randomized control trial as you would in a drug efficacy trial. And that's how we construct this control group or counterfactual world without warming. I am happy to delve into the mechanics of the approaches we use in my group if the committee has questions about those. I also will send 3 scientific manuscripts with my testimony today that document our work and our methods. We've applied this framework to assess the income lost due to historical emission-driven changes in average temperatures and in extreme heat. I note that we can eventually extend this type of work to other hazards to include floods or droughts, or into other damages such as mortality or morbidity, depending on the use case. We know from these individual damage assessments that the cost of climate change to date are far higher than previously understood. And because the costs attributable to individual hazards like heat waves are so large, and because they focus on quantities that are easily measured like GDP, it is my assessment that any accounting of damages to date are an actual undercounting of the true losses from climate change and are therefore conservative. Thanks for the opportunity to chat with you all today, and I'll stand by for your questions.
Okay, well, thank you very much. Thanks for the high level picture as well as the additional detail. This committee seems to have a passion for digging into some of the details, so I know we'll be doing some reading offline and maybe follow up with a few questions. But any committee questions for Mr. Mencken? General McCormick.
You have a dollar figure?
For what hazard and for what kind of damage?
Well, let's start with the big one and just the aggregate. The total of artificially, unnaturally contributed atmospheric carbon.
So the question here is how we go, like what is it that constitutes the impacts of global warming? They are multivariate, right? Carbon emissions go into the atmosphere. That atmosphere alters the radiative balance of our planet. That alteration of the radiative balance of our planet changes the redistribution of energy that we experience as weather and climate. And that redistribution, to the extent that our lives and well-being are acclimated to a certain distribution of temperature and precipitation and those types of things, we endure losses to that change. The question you're asking of, do I have a dollar figure? I can tell you how much income Vermonters have lost attributable to emissions-driven changes in extreme heat. I can also tell you how much Vermonters have lost in terms of income due to emissions-driven changes in average temperature. And those costs are distinct, meaning that the costs associated with, say, the 5 hottest days of the year and how that fingerprints and impacts Vermont's economy is distinct from the sets of costs associated with just average temperatures. And so the question is, you know, what sets of hazards are being considered, right? And how are you choosing to monetize those? A clear way to operationalize this, and the way we have done so in my research group, is to look at income, which is GDP per capita changes. There are other ways to do these damage accountings, focusing on, say, insured and uninsured losses, which is a different framing, but equally defensible. The point is that there are myriad tools available for the treasurer to pursue an accounting based on, policy choices. Those are not scientific ones.
Thank you very much. Any other committee questions for Professor Mencken?
Question for you. Are there, this,
Yeah, we
Mr.
have-
Mayor is our only witness on this.
Actually, we have Mr. Iarapino who
Then I'm gonna stop.
offered to come in. So if there are no more questions for Professor Mencken, we'll invite Mr. Iarapino to join the table. Thank you.
Thank you very much, Mr. Chair and Committee. For the record, my name is Anthony Arapino. I am a private attorney at the Montpelier law firm of Wilczek Arapino Law Office right down the street from you, where they're still banging hammers and pulling up floors because the first floor of that building was completely underwater in the second 100-year flood I've lived through in my 20 years in this town. And that has displaced 3 very hardworking small businesses from the core of our city. So I come to you as a partner at that law firm, but as a registered lobbyist for the Conservation Law Foundation. And I make that prefatory remark to let you know that this is both professional for me as well as personal. And I think that's true for many of you and your constituents. I know we're close to time, so I'm gonna race through my testimony, but I did provide a written copy of my remarks that are tailored specifically to your committee. To your committee assistant, it's been posted, and I've also testified at length in Senate Judiciary. I'm happy to make any of those materials available. But I think, just to reemphasize, climate change is an existential threat to Vermont. We know this, and we know that the burning of fossil fuels, extracted, refined, marketed, and sold by some of the largest companies in the world and the most profitable corporations, has overheated our planet. The consequences of this overheating have been well and disastrous and costly for a state like Vermont and its residents. We're not prepared. We're not prepared for what lies ahead. We don't have a clear strategy for adaptation and resilience. We have not forecasted the costs. And even without such a cost calculation, we know we don't have the money to pay the full cost of the projects and programs necessary to help keep us safe and help us recover from the worst of this unfolding crisis. Those are the problems that S259 will address. S259 sets us on a course to, and I'm quoting from the bill, respond to, avoid, moderate, repair, or adapt to negative impacts caused by climate change, and to assist human and natural communities, households, and businesses in preparing for future climate change disruptions. How are we doing this? There are 4 critical steps in the bill. This bill has been carefully crafted with fundamentally sound constitutional legal concepts from the hazardous waste cleanup cost recovery context, coupled with the cutting edge peer reviewed climate science like that being conducted by Professor Mencken, Rick Heady and their colleagues. And it's a bill that will meet the existential crisis head on in a systematic, stepwise way. And that hazardous waste cost recovery that I was referring to, that's the PFAS forever chemicals is one example of that, the St. Gobain situation, which I know your chair referenced yesterday when Senate Finance was talking about this bill. So anyways, going to the steps we're going to take to solve the problem of our lack of preparedness and the lack of money we have to pay the full cost. Step 1, ANR, with the help of the treasurer, devises and adopts the resilience implementation strategy to identify the scope and scale of the projects that we need to accelerate resilience, adaptation, and recovery, and set forth a methodology for funding those projects wisely and efficiently over time. Critical first step. Step 2, the treasurer's office, working with experts throughout state government, working with experts like Professor Mencken, working with contracted actuaries, because there is an appropriation for that in this bill. The treasurer tallies the costs of historical and likely climate damages that are attributable specifically to the emissions of the largest fossil fuel companies in the world. And again, as Professor Mencken and Rick Heady and others, we have the scientific tools to do that. In fact, we're probably going to be conservative in our application of those scientific tools in step 2. Step 3, ANR uses the treasurer's bottom line cost calculations to determine the fair share each fossil fuel, major fossil fuel polluter pays in proportion to the amount of global overheating pollution attributable to their enormously profitable extraction and refinement activities. ANR then exercises its judicially enforceable authority to assess penalty demands for fair share cost recovery to those big fossil fuel companies that are subject to Vermont's jurisdiction. And finally, step 4, ANR distributes the fair share payments collected from big oil to pay for the climate adaptation projects that are consistent with the resilience and implementation strategy. This bill is the total package. Each one of those pieces of the package is critically important. The steps that are laid out in the bill are fair, rational, and necessary in the face of the climate crisis. I want to pause for a minute on step 3. We have both the scientific and legal tools to get the job done. The bill establishes strict liability based on the substantial amount of greenhouse gas pollution attributable to fossil fuel extracting and refining. Polluter pays strict liability is a well-established concept in Vermont and federal law. Again, your chair pointed out yesterday in Senate Finance, this is the same thing that this body did a couple years ago when it came to manufacturers of forever chemicals that are polluting the wells and the grounds in many communities throughout the state. So you are building on a solid legal foundation. Strict liability does not require proof of wrongdoing, negligence, or mental state.
Yeah.
Okay, all it requires is proof that you engaged in the polluting activities to which strict liability attaches. In this case, that's extracting and refining fossil fuels that resulted in at least 1 billion metric tons of CO2 equivalent emissions from 1995 to 2023. Now, I can't break that number down in a way that's makes sense for you, but you should look at the testimony from your colleagues in Senate Judiciary, because Rick Heady, who is one of the people who's added up all the pollution from the fossil fuel emitters, he had some staggering numbers about like the number of car trips back and forth to the sun that is equal to 1 billion metric tons, and was a big number. So we're talking about the most culpable actors when we go after the fair share payments from big oil. There is no disputing that the companies who would be held accountable under this bill engaged in the activities, and we can back that up with reliable, publicly available data from the Carbon Majors report, which was compiled by Rick Heady and others. I've put a link to that report in my written testimony, so if you want to look more deeply at that, go to my testimony, click on the link. That report has been peer reviewed and has been widely cited in many policy contexts. So the focus of this bill, it's not about extracting retribution on large fossil fuel companies because of intentional wrongdoing. It's about adjusting the benefits and burden of the economic life to recognize Vermonters and our taxpayers cannot carry this burden alone while the fossil fuel companies profit enormously. They should pay their fair share. It's not punishment, it's adjusting the economic benefits and burden. There's a lot more that your Senate Judiciary colleagues have heard on this. I commend the record of that to you, but I will just quote from our Attorney General, who came after several legal and scientific experts in the field testified to you, Senate Judiciary Committee. She said that she supports the policy behind this bill. That's a quote. She believes in a polluter pays model, and it makes sense that the major contributors to the climate crisis we are experiencing here in Vermont should pay a fair share when it comes to our costs with dealing with that crisis. We know that they're not going to pay willingly. They will probably resist in court. And the Attorney General has said, quote, if we are sued, I will proudly defend this bill. Your colleagues in Senate Judiciary also received letters from numerous of the top legal clinics at Yale Law School, Vermont Law and Graduate School, for example, saying that if industry comes to try and stop the state of Vermont from holding them accountable for their fair share, those clinics will pledge their resources to help defend it. And based on my experience as an environmental attorney, when, for example, Vermont was the first state to adopt the California Clean Cars rule and was sued by industry, Conservation Law Foundation was there along with other groups to help defray the cost of defense and to add firepower to the state. And I am sure that will happen if industry resists in court this time. There is one last point that I want to emphasize about the legal underpinnings of this bill. The AG currently is suing ExxonMobil and another a large group of major fossil fuel companies under consumer fraud theory. That is, unlike this bill, about intentional wrongdoing. Okay? That we applaud that lawsuit. It should go forward. It's a strong case with a good chance of winning and bringing some money back to the state, maybe even money that could be helped to run and defend this program. But that case has been made very clear in the complaint. It is not about recovering environmental and other economic damages that Vermont has experienced as a result of the fossil fuel industry's lies. It is not about that. It is about punishing them for their lying behavior. S-259, by contrast, is about getting that much bigger pot of money here to Vermont to help Vermonters prepare for and recover from climate change. So it's really important because there has been some confusion in this building about, well, why would we do this if the AGs are already suing? Two different issues, two different pots of money, even though it's the same polluters in one case, bad actors in the other case. You can make your own value judgments, but it's important that you understand and keep those separately. The last thing that I want to leave you with has to do with the fact that this bill is urgent. Time is of the essence. Everyone who lived through the last year in Vermont understands that urgency. That being said, your colleagues in Senate Judiciary were sensitive to the concerns of the Vermont Agency Natural Resources, that its hardworking staff not be asked to do too much too quickly. As a result, the committee's amendment takes heed of that and has set an extended timeline for the treasurer and ANR to complete their work, including an interim report, which will come to you next session, that will allow all stakeholders to identify and seize on opportunities to improve the design and implementation of this bill. So it's very much setting up a process that has built into it appropriate checkbacks to make course corrections and improvements as needed. This approach also has the benefit of phasing in Vermont's investment in the necessary steps that I laid out above, so that we can budget to get the job done over several fiscal years, recognizing that it will take a sustained investment. But if we spread that investment out, it should be manageable for the taxpayers. So it's time to adjust the benefits and burden of the climate crisis so that those who have reaped and continue to reap extensive financial benefits bear proportionally fair burdens. Those heavy burdens to our physical, mental, and economic well-being now rest entirely on the shoulders of our taxpayers, small businesses, farmers, and on those populations disproportionately and historically disadvantaged and marginalized. They can least afford it and they are most in harm's way. The major fossil fuel companies must pay their fair share for that burden, and S259 is the way that you can exercise your very powerful police power, as it's referred to in constitutional law circles. It's been reserved to you by the US Constitution under the 10th Amendment. This bill is a valid, rational exercise of that power. It's a bill whose time has come, and I strongly urge you to support your Senate Judiciary colleagues in voting for this bill when it comes to the floor. I note that the bill was a 5-0 tripartisan majority in that committee. And I note that the Agency of Natural Resources contributed testimony and meaningful input to the structure of the bill that's coming to the floor. So I appreciate the opportunity to speak to your committee. I had a lot more to say, particularly about what the fossil fuel companies knew and when they knew it. And that, again, is not about holding them accountable for wrongdoing. That's what the AGs are doing. It's about the fairness of retroactively looking back in time and saying, you owe us for the damage you have caused and are causing. Thank you for your time today. Happy to take any questions and commend you to check out what I've submitted.
Right, so you've submitted your written testimony.
I have you very much.
We are over. Thank you, committee, for saying on.
I think you have.
Anyone has that's it. If someone wants to stay and talk further with Mr. Iapino, please do. Otherwise, I just know that people need to get to lunch, to the floor. Thank you again.